Hi, and welcome to another edition of the Trustcast Show. I'm really excited to have with us Frank Poe. Welcome to the show, Frank.
Hi Zane, how you doing?
Great. So Frank grew up in the '90s skate, hip hop, and punk culture, became a talent agent for celebrities and musicians, and then spent a decade as a litigator and in-house counsel for a celebrity agency. And he now runs Poe Law, the firm quietly cleaning up the wild west of the creator economy, one shady contract clause at a time. So you review creator contracts every week. What's the wildest clause you've ever seen in one?
It's funny. We're entering a world where a lot of things are, a lot of brands are trying to get into the mix, and we get a lot of regulated products, and
Hmm.
so brands are trying to kind of balance that sort of the regulations. Let's say that's a quasi medical product or a beauty product that has some kind of medicinal quality. They try to own the content. They try to frame it in a way that they're compliant with the regulators for doing that, and it just gets very wiry. And I ended up on a call with 8 different attorneys for a brand at one point. It was just me, in my basement doing the deal, and I'm like, listen, guys, it's not that difficult, but it gets tricky, and there are a lot of moving parts and pieces. But I would say, yeah, I mean, there you pile on those complications, and you have to unpack that and just really see it for what it is.
What kind of client did you have in that instance, just to kind of put the whole story together
So
so I understand what you.
what this typically happens is I represent a lot of management companies, and they have a roster of creators, and what'll end up happening is they will receive inbound offers from brands of all shapes and sizes, for their
Hmm.
creators to work with them and do a partnership. They'll create content, and really it's simple enough to create content, test the product, post it, allow the brand to use it for a certain period of time, and that's pretty much it for a fee. But when these brands come along, they're coming from all different areas, and it's kind of like if you had a room of 100 people and you told everyone to describe a fish, and you're going to get 100 different sort of interpretations of what a partnership is supposed to look like. And my job is to kind of wrangle everybody into sort of a similar picture so that my creators and my clients have a sort of expectation of the rights that and the value and everything that they're getting out of this. So it's sort of a mixture of balancing a balancing act, but also accommodating for different kinds of brands and different sizes of brands.
So when you're talking to potential new clients, or who are your potential new clients? Are they the creators themselves, or are they the brands, or do you have a little bit of both?
It is a little bit of both. What I find to be successful on both sides for myself and for creators is when they band together or when they join up with a management company or a talent agency, because that helps spread the cost a little bit more. I think traditional law firms are more inclined to charge hourly and things like that. In the creator
Hmm.
economy, that's less so. I'm more of a, flat fee or subscription type of attorney. And that's more useful and more valuable when I have a nice sort of bulk of deals and agreements and deal flow to do. So when I have agencies or managers, it's a lot more manageable for everybody. The costs don't go up and down and go all crazy, and I don't have to worry about billing so much. I don't have to worry about all that. And so I will work with creators directly. Sometimes I'll, especially if they're growing and emerging, I'll work with them on like a percentage basis. But for the most part, I prefer if they somehow banded together and they got with management, or I'm dealing with an agency that can kind of oversee a larger campaign so that I can be more efficient for everybody.
So when you have an agency, how do you grow your business? So basically, you're marketing yourself. I mean, you probably do a lot of word of mouth at this point. But when you're marketing, which I assume you do some marketing, who are you marketing to?
It's very little marketing. What I do is I kind of frame this as sort of pull marketing instead of push marketing. I think a lot of
Uh-huh.
people push their narrative, they push what they know, they push their expertise, they push out content, they push their story. I don't necessarily do that. I engage with people on LinkedIn. I write my pieces every Sunday. That's just is sort of an FYI, like here's my take on this article or here's my thought on this, and I find that that pulls people in, especially people who are more viable candidates to actually want to sign up with me and work with me. And I also just build long-term relationships. I've had relationships since I started Poe Law. I had a great meeting with a fellow who started his own management company, and he didn't sign with me until like a couple weeks ago. So you think about, how um, you can build those long-term relationships, and they tend to be stickier. So I would say that my growth engine for my business is not so much virality or having my face everywhere or trying to put my services into the hands of everyone. I think it's
Mhm.
more about seeking out those sort of ideal folks. And on more than one occasion, I've had, clients, when I first meet them, go, "You're exactly what I'm looking for. Like what you're doing right now is exactly what I need." And that's how I know that I have a client that I can really build something. And I do. I see a lot of these smaller management companies build, little by little, they add more people to their roster, they get more deals in. And I also tell them, I said, use me and allow me to help empower you to take on deals that maybe are a little more complicated. Maybe we can explore those a little bit more, and we can assess risk, and you can raise your risk profile a little bit so that we can get better things in the door. And my clients, are into that. They're into exploring that with me.
So often I see attorneys are really into no, not KNOW, but NO for when they're working with organizations. And
Yeah.
as a creative, so I mean, you know this for sure. I mean, just the example you gave of the 8 attorneys in a room, probably all of them saying no. Um, and you're the one saying let's do this. So how do you I'm sure it's a little bit different in the entertainment industry, and you probably have to be a different kind of lawyer. Can you maybe talk about that?
Yes, yeah. So I think there's a trend now of people talking about being the lawyer of yes. And I think people are leaning into that a little bit more, and they're trying to be more collaborative. I think that the traditional entertainment business obviously has their traditions and their ways. The creator economy, which I've sort of shifted over, and like my timeline in my practice from being a talent agent in the entertainment space, moving into and away from like my traditional litigation practice and into sort of the creator economy space. Um, there has to obviously be an honest assessment of risk. So I think I'm
Hmm.
not necessarily a yes or no lawyer, but I try to be a real lawyer. I try to give them the reality, and I say, here's what the risks are. And if you're going to roll the dice, I'm with you. I'll be on the other side of this. I'm going to be, I'm going to take you through this whole step of the way. So I'm not saying no. And it's really not my position to say no. It's really the client's choice. But the trick is to give the client as much reality as possible so that they're making the best informed choice. And I go, I'm like, I'm with you. I'm going to stick by you. I wouldn't necessarily like this, but that's not my choice. And I try to stay within that sort of that reality realm. I also don't overindulge. I don't think it's like I have to figure out ways to make this deal happen, because there are many times where the legal side is really the filter.
Hmm.
I also often say that the business side is the gas and the legal is the brakes a little bit, kind of in that traditional sort of no mentality. But you can't drive a car without both of them. You have to be able to
Yeah.
move forward. And sometimes I'm a filter where a brand will come in and I'll review everything and I'll say, look, there are so many red flags here. Like, this is really bad. And the business side, if they can see that and they can acknowledge it, then they will turn around and say, you know what, you're absolutely right. We will drop this because this is not going to get better. This is only going to get worse. So it
So give
helps
me an
to.
example. I want to,
Sure.
because I want to dive into that idea for dig a little bit, because I think that's an interesting topic. So can you give me an example
Sure,
of
sure.
something like that?
Very often I deal with marketing agencies. So the way that works is brands will not do a lot of this in-house. Some brands will, some brands won't. But a lot of brands will sign on with marketing agencies who really just kind of, do the media buying, and they figure out what influencers to, engage and talk to and all that kind of stuff. And so what they will often try to do is they'll try to figure out a way to remove the brand as the principal and they're the agent, remove them from the situation, or at least remove their liability. So the agent is like, listen, I'm throwing this at you and I'm not liable for anything. And, I don't have to pay you until the brand pays me. And I'm like, well, no, you can't do that. And I tell my clients that's a major red flag because you're the agent. Your job is the one job is to get the deal done. So if you can't get the deal done, then why didn't I just go to the brand directly? And so I usually see that as sort of a red flag. If the money is sort of hiding somewhere, it's not,
Hmm.
right in front of you, and you get these weird terms that are kind of distancing themselves from the responsibility of what they're supposed to be doing, then yeah, that's a red flag.
So, give me an example of what would be a typical deal that you might put. I mean, without disclosing, obviously
Sure.
inner workings. Maybe a typical deal that you'd be working on.
Yeah, for sure. So a typical deal is, a brand will come to us and say, we're going to send the creator product. They're going to try it out. We're going to jump on a briefing call and talk about, how they felt about it and all of that. And then we're going to ask you to post maybe one or two Instagram stories over the span of a month. And maybe we'll have you do an Instagram reel, and maybe you'll move that over to TikTok and have that on two different platforms. And you're going to run that for a period of time. And we're also going to ask that we can take that footage, we could take that those posts and repost it on our channels for about 30 days, maybe 60 days. And we're going to pay you a flat fee to do all of that. If we want to re-up, if we want to do more, we will negotiate that. Very often after 90 days or so, you're typically going to want more or new content. So you go back to the creator and say, hey, can you post another video? Can you do another thing? And the payouts ought to be somewhere between 30, 45 days. Lately, there have been a lot of brands who are pushing out more towards 60, 90, that kind of thing. And that's when you get a little wary too. It's, if you're coming to the store, you can't say, well, I'll gladly pay you Tuesday for a hamburger today, right? The old saying. So like, that's, how much credit can we extend, especially as a small individual creator
Right.
who needs to hire someone like me to chase after them for money or something like that. So probably the least favorite part of my job. Yeah.
So, how often does that? So, how big are the? I have so many questions to run through. So, have all these questions written down, but I'm not getting to them because you're kind of getting my brain going.
We
So,
have 10 hours. We could do this.
how big are the brands and how big are the creators that you typically handle?
It does vary. I do work with, so I have a management company who works with celebrities, the wives and girlfriends of athletes and reality TV stars. And then I also have, groups that work with sort of the micro or nano influencers. I would say on average, you have just sort of your, not to say every day, but they're sort of your working creators. They post, they make enough money to put, to pay the bills, and they feed their families with it and stuff like that. And they can do that because really this is all about them managing their own community. They grew a community of following. It could be anywhere between, 30, 50, 100,000 followers. It could be 200,000 followers. It could be 1.1 million followers. It really does range. And then on the other side on the brand side, it could be early stage startups who are looking to, market very effectively, and creator tends to be the most effective as opposed to like a shotgun sort of out into the world traditional marketing plan. And then it also could be the Fortune 500s who they are issuing a campaign for thousands of creators to go out and to sort of leverage their audiences to bring awareness to their brand. And to the extent that you're aware of like sort of the sales funnel, the top of the funnel is really awareness. It's the widest part where you reach the most people, and then you sort of narrow it down into sort of understanding the interests of those followers, and then finally at the very bottom is the generating that sale. So you typically find the influencers sort of in the middle to bottom part, and then you find celebrities towards the top where Tom Cruise is raising awareness, right? You're not necessarily going to get into the technicalities of how he makes his coffee and stuff like that. You really just care that he's on screen showing you which coffee to buy, right? So it's sort of a, personally, I work with all ranges because everyone's kind of swimming in these waters at this point, and sorting this out and finding value in it.
So, a creator just got their first real brand deal, and a contract hits their inbox.
Mhm.
What's the first thing that they should do before signing that? Because they're excited. I want to, whoa, I got this deal. And the company says, sign it and get it over. We'll get started right away. What should they be doing?
So I have a general framework, and I'm shopping it to publishers in book form. So it's called the REV Model. So you're looking at your rights, your expectations, your value, and your visibility. So your rights, you got to know what rights you're obtaining and what you're giving away, right? Is this a thing where you're creating this content and you're just giving it to the brand to own, or are you licensing it for a period of time? The expectations, do you have to keep, confidentiality? Do you have a morals clause so you don't act up and, get in trouble in the public and they terminate your deal? What is the value? Are you getting the amount offered to you that was in the offer? Is it in the contract? Saying, does it match? Are you getting the money that you were promised? We have a lot of issues where the brand demands that they withhold money for taxes and things like that when the creator's an independent contractor, and so that can kind of provide that could be troublesome for the transaction. So you have to watch out for things like that, and then visibility, which is kind of a look back at all three of those kind of categories. Do you have visibility over your rights over a period of time? Does the brand say that they want to be able to license it to whoever they want, and who could those people be? What's and the value? Are you doing a collaboration with a brand for a product? Are you receiving royalties for the length that they are marketing that product out there? Or are you just getting a quick flat fee and that's it, but they're going to go on and use this forever? So it's you definitely want to look at sort of those different buckets. So I would say the first thing is obviously your rights. You want to make sure you understand what your rights are, because at that point you could always fight for your value. You could always say, this is what it's worth, this is the fair market value, and this is what I should be given.
So the REV model had rights, value, visibility. What was the one I missed in between the E?
Expectations. I think
Expectations.
brands and brands will have to rep and warrant things, and the creators have to represent and warrant that their content won't infringe anybody's third party rights. That they're able to enter into the agreement. Both parties have sort of expectations of each other about what
Hmm.
has to happen in the agreement, and that's very important too, because you don't want to slip up on those, because on a technicality they could say, hey, you're done here, right?
So, what's the single most dangerous clause hiding in almost every brand contract?
uh, I think that what ends up happening, and I appreciate that question, because sometimes it is the little things. I look at choice of law a lot. So typically companies, when they first register to be entities, whether they're C corps or whatever, they very often will file in Delaware. Most business owners know that filing in Delaware and certain other states are very, advantageous to them. What's
Hmm.
interesting about Delaware is that Delaware does not recognize, in any great extent, the right of publicity, which is really sits at the heart of these creator deals. You're licensing your name, image, and likeness and your content to the brand to use for a certain period of time and to gain value. So if you're venuing and you're having this agreement adjudicated in Delaware, you're pretty much giving up a lot of your ability to fight for the core of the agreement, because the brand decided that because they initially filed their LLC there, that's where they have to litigate. So people should really look out in those details at the bottom, the boilerplate, what a lot of people call, because that's those procedural things and those little things on the legal side can have a lot of impact. Not to mention attorney's fees. A lot of people just assume that, oh well, the winner gets attorney's fees. Well, the if the company wins, the attorney's fees could bankrupt a creator, overnight. Whereas if a creator wins, they're paying me like whatever my fee was, and that's a significantly different thing.
So, do some companies, they go into a deal and then they just start an LLC in Delaware so that they can do what they want to do? Do you see that?
Well, I think that I think that it's been very common for many many years that corporate governance is very it's a lot easier in Delaware. The requirements are not as heavy in Delaware. So when business owners start things out, when they start their companies, it's usually advised that they go to Delaware, right? Or if you're a company that's from overseas and you want to enter the U.S. market, you want to establish roots here, you'll file in Delaware. Is usually where people are steered toward. So it's not much to turn and say, listen, you could say, like, we understand that you're registered in Delaware, everything, but the law is more robust in, say, California and New York, etc. It's more robust in those states, so why don't we just agree to settle those disputes there? Or we'll supplement Delaware law with another state law that does recognize, because my client is not giving up a claim just because you registered here. It's not relevant. Your registration there is not relevant, especially because most of their offices aren't there. They usually file in Delaware and then they're located somewhere else. They're in, Wyoming or Nebraska or whatever it is. But it was advantageous of them to file in Delaware initially.
So, do you get pushback when you bring up something like that?
So it's a great question. You would be surprised how little legal there is on the other side of most of my deals. Very often I'm going toe to toe with CMOs. I've had to go back and forth with paralegals. What ends up happening is that these brands, I mean, I laugh at the larger brands who sort of rely upon, these teams to just get the deals done, and they don't want to look like, there's trouble. So
Mhm.
they don't want to run back to their attorney all the time, and I'm showing them very glaring issues with their agreements, and they're hesitant to go back, so they try to wing it. And I would say that very, very often a lot of these brands will say, okay, we'll accept your suggestions, whatever, let's just get this deal done. They just care about getting the deal done. And, for what it's worth, it's not like I'm putting nefarious, awful things in there. I'm just trying to get more clarity. I'm trying to preserve rights, and I'm trying to reduce exposure to the singular creator as opposed to this large brand that they're going up against.
So I can see. So you're the story that you're illustrating in my mind, I think, is both sides are excited about getting the deal done, and maybe they set aside their better judgment. Is that accurate?
I think that's fair. I think that it's a numbers game for the brand. I think if they're dealing with a large campaign, they have a bunch of people. Sometimes it cuts the other way too. There are some marketing agencies out there who say, listen, if your deal is not under 25,000, we don't accept any red lines. You either take our agreement or leave it. And I see glaring issues with their agreement, and they won't change them. And it's funny because there are some management companies that I work with that are my clients who will keep going back to those brands, and I say, well, we've done more than $25,000 worth of deals with you, so why aren't you listening to me? It's kind of silly and bad faith, but I think that for them it's a numbers game. They want to get the deal done. You're right. They want to get the deal done. They want to push it out. For them, they see it as low exposure. There's some irony in that, and I've got some great stories for that. Because very often a brand will come back to me and say, Frank, this is only a $2,500 deal. We're not going to entertain any of your red lines because it would just cost too much to deal with. And that's a big mistake because the sticker price on the agreement, the fee on the agreement is not relevant to the amount of exposure that you could see. And why would a brand risk a $300,000 lawsuit over a $2,500 deal? Why not take the
Right.
time and look at the issues and fix it and guard yourself? So, and the irony is that sometimes what I'm putting into the agreement is a limitation on liability, capping it at that sticker price. So they're rejecting their own argument. They're saying, we can't limit liability. We can't accept your notes to limit liability for everyone, because the amount is too cheap. And I'm like, that's literally you're fighting against yourself at this point. It's very bizarre, but I just and it goes to show sort of the inexperience that goes into it, and um, I keep praying for the other side to be reasonable and come back and say, oh, we totally get it, we totally understand where you're coming from, and I'm thankful that a lot of times it does happen that way. But yeah, some of these outliers, forget it.
So how long is too long when a brand says, "Oh, well, we want you exclusive"? What should a creator ask for in return? Especially like if somebody's kind of catching fire, and you can see this. I'm running through a scenario in my mind. So where somebody's kind of catching fire, they're
Hmm.
really got a lot of momentum, and the brand wants to lock them up. How do you advise them? They tempt them with some a pretty good size amount. How do you advise them on that kind of scenario?
Well, I'll take you one step further, where there's a lot of trends right now about talking about equity deals, right? Equity and financial mixture. So I think there is a mistake in that people focus on the emphasis between the relationship between the creator and the brand versus the creator and their audience. The real value is the creator and their link to their audience. If you stick
Hmm.
with a brand for too long, you start to become the brand, right? You're assimilating. It's like, the body snatchers, right? You're suddenly now a part of the brand. And so it's healthy to maintain your sort of organic, authentic, sort of individual self and not so much assimilate with the brand, because your cachet, your value is going to go down. And then it's just a matter of time. I mean, if you look at it from a creator's perspective, let's say they accept equity in a brand. Well, now they're part owners of that brand, so they can't go out and they can't work with competitors. So they've cut off an entire vertical of products, or a whole area and industry to work with now, because they're stuck with this one brand. What if the brand goes belly up? Or what if what if it's even worse, where they're holding on to their stock because they can't get rid of their stock for at least 6 months. They signed the deal, so they can't liquidate their stock. They can't sell it. Or what if there's a capital call in a year? So now the creator is paying the brand to be a part of the brand as opposed to the other way around. So I would say very often what makes more sense, let's say a brand wants to do a year-long commitment with the creator. I would say break it out. Let's look at things in 90-day cycles so that, you can do content, we'll release it, in 90 days we'll assess, maybe we'll do another round, and then maybe we'll take a break and kind of pulse it a little bit, because you don't want the creator to be too affiliated with the brand, because they start losing that sort of connection, or that independence that makes that connection.
So if a brand refuses to negotiate and tells the creator the contract is non-negotiable, does that really mean non-negotiable?
I will say, no, 100%. Like I say this all the time, that deals should never get canceled over red lines. If they do, that's another red flag. That's one of those filters. If they're,
Mhm.
and it's funny because most of the deals that have tanked because of me, were really, they didn't have as many red lines as a lot of the other ones do. There's maybe one or two edits or notes, but it was just the ones that I went after, the really weird things that were in there, and they didn't like that very much. And I was like, well, wait a minute, if they're so, hell bent on keeping those in there, um, it can come off as a red flag. And what I mean by that is usually like that they're trying to avoid that liability, because maybe it's the case that they don't have the authority from the brand. Maybe they're just kind of like they're bluffing a little bit, but they can't put that in the agreement. So no, I think what ends up happening is I will go back to the manager, I'll go back to the creator, and I'll say, listen, this is not a great agreement. I'm not happy with it. If you want to roll the dice, here's a risk assessment. I've now turned my contract review into a risk assessment. It's a list of risks of, by accepting the agreement as is, here's what you're taking on. Some risks are worth rolling the dice. Some are just clear, like they're just bad. But if the creator doesn't care and they want to go forward anyway, that's their choice. And they've done it, and we've gotten the deal done. And, by the skin of our teeth, the brand either didn't take advantage of it, or they didn't realize that they could, or they didn't read their own contract, or whatever it is, and it went smoothly. But I never worry about the intentions of the person that I'm talking to at the brand. I'm always worried about their future lawyer who looks at it and goes, oh, did you know you could do this? And that's usually my concern.
So, and in the real estate business, I was involved in a number of different real estate transactions, and were always looking out for what we called the weasel clause. Allows them to. So you're kind of talking about a similar thing, although it
Mhm.
maybe not have that.
I'll use that from now on. The weasel clause is most certainly not 100%. I mean, in traditional entertainment, there are some agreements like holding deals and stuff like that where technically they're not enforceable agreements. They're just kind of like intentional letter promises that are not necessarily exchanges. They're kind of weird. And then there are a lot of situations where the agency will come to me and say, well, the brand can cancel anytime they want. And I'm like, well, if they do, you got to pay for that. That's a separate kind of agreement. You need to provide some kind of consideration in order to allow that to happen. There's very little weasel. Otherwise, this is just not an enforceable agreement. I don't make the rules. I just kind of learned them and follow. You know what I mean? Like that's the way it works. So yeah, I'm mindful of the weasel clause. I see it coming a mile away, and I say, guys, no. You're an agency. You either are committing to this and that you can bring the brand to the table, or you can't. And why don't I just go to the brand directly if that's the case?
So, when a creator says yes to perpetual usage rights, what are they really handing over?
They're handing over what I would think is an existential threat to their overall channel, because really what happens is when you enter into a deal, you're representing and warranting that there are no prior brand deals that are going to affect this one. It's not going to get in the way. Nothing, no traffic is going to get in the way of that. Some brand is not going to come out of the woodwork and post all this stuff about me that will, affect our current brand partnership. Well, if we're representing and warranting that for you, why wouldn't we represent and warrant that for a future brand? And the issue there is if you have perpetual usage and rights, you have that opportunity to do that. And so I can't enter into future brand deals. If I can't enter into future brand deals, my cachet as a creator goes way down and my value goes way down. And therefore, your use of my content in the future goes way down. So there's sort of house of cards effect that kind of collapses everything because you insisted on using it. Now, there are some brands who don't really understand that concept, and so they insist on owning it. They insist on all of that. So what I end up doing is I say, you can own it, but you have to come to us whenever you want to use it. You can own it, but you can only use it to the extent that it's allowed in the agreement. And if you want to use it any further, you have to come back to us. So you can have the car, but we keep the keys.
So I'm going to shift just a little bit because it's something that occurs to me that I've heard so many times about these talent shows on TV and
Hmm.
about people going on these talent shows, and then they're the one statistical aberration that actually becomes big, but they sign this contract, maybe a year ago, whatever, when they turned out for the show, and they almost give away all the rights. Do you have? Um, I think people are kind of interested in that topic. I know it's a little bit off topic, but it's still in your area of expertise. Can you kind of maybe discuss that?
Yes, I can. I do. Some are the like the game show type of deals. I do a lot of reality show deals too. I will review
Hmm.
those contracts, and like the ones where they're like living on the island and they're like mixing it up with everybody. Like there are a lot of clauses in there. There are a lot of things to be mindful of, because there are a lot of risks and all of that. And they are, this is we're looking back into more traditional entertainment deals where the golden rule is that if you produce it, you own it, right? You produce it, you can do whatever you want with it. The people who are showing up and participating, they're participants, they're or their talent or whatever, they really have no claim to those things. We're capturing whatever we can and we own it. And that is distinct from my creators, because the creators, they're the directors, producers, distributors, everything, and that's partly the justification as to why they should own it. So that's one of the major distinctions between sort of traditional entertainment law and creator law. And I think that traditional entertainment law, it's justified an incredible degree, because um, it's intended to be more evergreen. You want to be able to show it on Netflix and then show it on Hulu and then show it on whatever down the line, and be able to monetize that as much as you want. That's what you intended on doing from the jump. I think when it comes to brands and creators, the intention, we're dealing with a different concept. We're trying to make an impact in a very short period of time, given the distribution channels that we have and the audience that the creator is leveraging. It's a different process. So yeah, you're going to see that it's a little bit more draconian in sort of the reality TV and the game show realm, because the underlying use, the underlying purpose is far more vast. And and things have evolved since then. We're talking about a time, that kind of language. It was for, so many channels on television and, so many radio spots and things like that. And now the distribution has grown and grown and grown. It's a wonder how saturated a traditional rights holder can have with these kinds of properties.
So, if a brand goes silent after a campaign runs and the
Hmm.
creator is chasing payment,
Yep.
what's the actual move?
What do we do? We get into litigation phase. We put our hat on. We're gonna have to investigate, who are these people, where are they located. One trick I've done in the past, and this is sort of like my tool bag that I use, is I will order something cheap off their website. I'll determine where it was fulfilled, so their fulfillment center, and I'll sue the brand in the state where the fulfillment center is, and I'll also sue the fulfillment center. Because what ends up happening is the fulfillment center will wake up and go, wait a minute, we're not involved in this. And I go, okay, well, then I want all the information you have on this brand, and I want to know how much inventory you're holding for them, because the inventory is what really matters, because that's where the value is. If you get a judgment against a brand, you could liquidate their inventory and collect. This is also true about their IP rights. There's situations where you have a brand that has a patent, and maybe they don't have a lot of on-hand inventory to liquidate, but they have a patent, and you can license patents. You can do a lot with intellectual property. And so if you can get a judgment against them to go after that kind of thing, and you get those kinds of compulsory licenses, you can have the licensee pay you to make good on your claims, and the original rights holder, the brand that didn't pay, is either left with the difference, or they settled up. Um, this is sort of the more aggressive style of chasing after things. I think that the more proactive and the better approach is to get into the habit of doing credit checks and getting deposits, setting up escrow and setting up prepayments, so that agencies and managers can manage the funds and maintain them and release them only when the creator actually performs, and that there's some security and some confidence. And I do call upon sort of, financial institutions and everything to start getting into the realm of somehow either guaranteeing these fees or, financing them to the benefit of the creators and the agencies so that the brands can make good on them. The worst thing you can do is have a brand set up a Shopify email, and that's the only way to get a hold of them, and then they just disappear.
So one thing that comes to mind too here is a potential, I don't know, complication, let's just say, between the agency, the creator, and the company, and actually between the agency and the company. You sign a deal with the agency. I'm speculating here, or someone signs a deal with an agency, and the agency ends up collecting the money and from the company, but then just poof disappears. Is this something? I mean, agencies have not. There's really good agencies, and there's agencies that are not really good.
Yeah.
So is this something that you have to deal with, and how would you deal with that in
I
advance so that
have I have dealt with that in the past. And it's actually I have a story that goes even beyond that. But so the
let's hear it?
yeah, I'll set you up though. So to answer your question directly, if the brand hired the marketing agency and the marketing agency didn't go, that's really the brand's problem. The brand has to go get their money. The creator, it's like, you never paid me. The agent, it's an agent and principal relationship. The agent is acting on behalf of the brand. If they abscond with their money, that's really the brand's problem. So that's like the first sort of tidbit on that. I did have a situation where we booked a deal with I think it was an Asian, like, kind of like a game or an app company, and they wanted one of our creators to do content for them. We'd signed the deal. The company paid the agency. The agency turned around and paid us, and we paid the creator. And you'd think that would be the end of the story, but it's not. So what happened was the agency that was in the middle was a U.S. company, and the guy that was managing the funds put the funds not in his LLC account, but in his personal account. Then he paid us out, and within 30 days, he filed for personal bankruptcy. So I got a call from a trustee in bankruptcy saying, you have to give that money back because it's a part of his estate and it's not part of the company. And we had to, we have to deal with that. And right then and there, I came up with the line of, listen, money does not like making U-turns. And in this case, there's no way I'm going back to the creator to get that money. So I had it out. I called the guy's attorney. I said, listen, your guy is filing for bankruptcy right now. I have your trustee chasing me down. You guys have to fix this, And he said, look, just, there's law behind this. Throw some law at him, talk about it. We'll get rid of him, whatever. And I found law. There's this idea that if a brand, the traditional principle, right, puts money in a jar and hands it to their agent, their job is to hand the jar over to the other principal. It's not to open the jar and take anything out. So that's sort of the analogy of, the fiduciary responsibility that the agent has. So in a bankruptcy situation, that was never his money. It could never be his money. It was specifically allocated for him to pass it along. It was never something he would earn and consume in any way. So it couldn't be a part of a bankruptcy proceeding. So yes, in addition to agencies acting badly, there are some agencies who acted like okay, and then they screwed everything up and just were negligent about it, and I ended up having to deal with bankruptcy court. So all sorts of weird stuff happens. So it's good to have a good handle on all areas of law as you're dealing with all of this.
So where does the real money get made or lost inside a creator contract? Is it the fee, the usage rights, or something else?
Yeah, I mean, time is money, right? So I think that you know, there's always this tussle and debate about, it depends on which side of the argument you're on. Some would say that, and the creator would say that, having to go through the process of the makeup and the hair and getting ready and creating the content and all of that is the value. Once they finish the deliverables and they're done and they're ready to go, the bulk of the value of the deal has been won, right? And then the brand would say, yeah, but that's just, you're just getting us to the cliff here. You're not taking the plunge. You're not taking the plunge at all. You're not jumping. So we think that the value is in the usage and the ability to leverage that audience. So I think it's both, right? I think that there's a lot of value in the content that's being created, but there's also how you leverage the audience. And I think a lot of money can be left at the table from, um, being able to properly value those usage rights. What is the brand getting out of those usage rights versus what is the brand getting from that sort of engagement with the audience of the creator themselves? I think there's a mixture there. Some of the hardest things to see is attribution. Like, how are these things attributing to the benefit and the overall success of the brand? What we have seen in the past is that the creator campaigns in general have had a very positive effect on the other marketing channels of the brand. They start to see a lift in all of the marketing channels, and there's really no way to value that, to put a premium on that, but it is due, right? It is a thing where we say there is value there. We just don't know how to price that. And in terms of exclusivity is a tricky thing. I've seen exclusivity for one day. I've seen it for a year. I've seen it for 6 months. Like, it's really difficult to kind of pare down exactly the effect that the creator's audience will have in the relationship with the brand versus their competitors. And there's also this concept of sort of a natural exclusivity. If you're working with a brand, it's very unlikely you're going to go out and work with their competitor the next day. It just doesn't make sense to your credibility. So you're
Mhm.
not likely to do that, even if you agreed or didn't agree to it in your agreement. And that does have legs too. Like, if your brand is out there reposting your stuff for 30 days, 60 days, whatever, you're not going to go out and do a deal with a competitor because the messages are going to get mixed up. So there's sort of a natural exclusivity that happens. But at the same time, how we value that is also sort of up in the air and worthy of kind of figuring it out.
So here's an interesting thing, because this happens in all kinds of marketing, is that you brought up is the idea of attribution.
Yeah.
And if somebody says, "Well, we want X ROI," we're out there, we're going to invest all this money in the marketing, and we want X ROI,
Hmm.
and we want to know that you're actually pulling your weight, Mr. Creator, that this is going to generate this amount of stuff.
Yeah.
And how do you deal with that conversation, because it's almost impossible.
Yeah, I mean, it's performance rarely makes it into the agreement, and we keep it that way. But performance still remains on the business side. So I like to think of it like the agents and the managers that I deal with are consistently dealing with performance, but when I see it in the contract, it doesn't show up. And really, that just determines whether or not the brands are going to continue to work with a creator or a group of creators. Ideally, in attribution, the brands are looking at a long-term effect amongst a big swath of creators and not just a single post or a single moment or whatever. It's happened on many occasions where the first post doesn't do so well, but then the second and third tend to improve upon it because the creator had built the trust of the community that they run, that they work with. So over time, it could be a building of trust. Now, that's more money coming out of the pocket of the brand, but that's the investment. So I think that, when it comes to attribution, hopefully brands have become more and more wise to the idea that a more long-term view, even if it's a short-term type of post, a more long-term view over time, and a re-up and a buy-in and a reinvestment into creator, we'll see the results, as a whole. It also helps when you have a single agency, like one of my single clients, able to capture the entire budget of the brand as opposed to a small portion of it, because then they can
Mhm.
allocate it. They can test creators, but they can also put some of their more higher performing people, also in there and kind of mix and match and be able to sort of play with the numbers and hedge bets. That's really what it comes down to, is hedging your bet, saying we're going to try and reach this ROI. But we're going to set the bar here so that we definitely make sure that we can reach a certain level, and be able to maintain that. And that's some of the stuff that my guys are really good at doing, across the board. They just kind of understand that, not so much intuitively, but they've had to see it over years of experience and the data exchanges and the, all sorts of information that come across and how to make this work.
So, when a deal goes sideways
Hmm.
mid campaign, what do you actually do, like in the first 24 hours? I mean, I know this happens.
Yeah, well, I mean, with termination, we usually say that both sides have some form of cure period. It's, pretty intuitive that for most contract breaches, it's like you have 5 days to cure, but for posting issues, you typically want to do something much shorter, 12 hours, 24 hours. The brand's on the phone with the manager saying, "Hey, they put up the wrong thing, the link isn't working." And it's really tough to fix out of the gate because now the creators or the creators community has seen it. So they first got a chance to engage with it, and that it's that first sort of round of impressions that really matters initially. But how do you fix that? So um, when it comes to my desk, it's usually less so about that performance and more so about how they valued having to terminate midway for one reason or another. We go back to sort of expectations where it's about like the morality. So if somebody does something morally unsound during a campaign and they want to terminate, they have to show us like what happened. And do you value the all of the posts and everything that happened before that got out, or do you just say, listen, you we can't work with you, and everything that we saw before we're going to lose going forward, so we can't pay you anything. So really it comes down to sort of assessing the aftermath of whatever quick hiccup happened, whether it's a technical issue, a performance issue, or anything else.
So here's an interesting question, or I think is an interesting question. What kind of paper trail should creators be building every single day that they're not?
Um, I think that what ends up happening a lot is you'll get a lot of these deals done over text message. I think I recommend that if it's a manager or if it's the creator directly, just jump on an email and just really just regurgitate it, just, or if you get on the call or whatever, just put it in email, get an email string going. I mean, I've had to review tons and tons of email threads over the years of trying to figure out what the deal was and all of that, and then hopefully within that process there's also a contract that comes out. Really what I want to see is I want to see sort of offer template that kind of lists out all the things, the brand name, the creator, the deliverables, like what they were supposed to do, the usage rights, the exclusivity, like all the basic deal points. I kind of want to see that in a nice little outline format. And that enables me to compare it against the agreement. And then the agreement itself should definitely be a part of that paper trail. And there's also the aftermath. There's also after the deal is done. There's a lot of reporting requirements. So they should be saving their their data, their metrics, everything that happened to kind of show how that performed and whether or not it met the brand's KPIs, key performance indicators, like what happened. And so they should be keeping records of that as well, because it not only helps from the prior deal, but also helps in future deals. They say, well, how'd you do with that brand? Well, I could pull up my the performance and show you how that worked.
So, let's just do a few rapid fire here just for fun.
Sure.
Skateboard or snowboard?
Skateboard.
Last concert you went to?
Oh goodness. I want to say it was a Bad Religion concert. I want to say that, but I'm probably wrong. There's probably something in between, but that's the one that sticks out in my mind. It's a SoCal Punk. So,
Handshake, deal, or 60-page contract, which scares you most?
I would say the 60-page contract, really, because God knows what's in that thing. I mean, it's just probably redundant and it will kill my day.
Worst clause you've ever seen in one sentence?
A one sentence confidentiality clause. I don't know how they did it, and I said, "There's absolutely no way this is going to work."
So you once reviewed a gaming contract with a 3-year non-disparagement clause at $2.50 per impression. Tell me about that.
Did I do that?
This is what my research says, but every once in a while we get something wrong.
Well, let's entertain that. Did I do that? I don't think so. I don't. Here, I mean, look, this is one of those situations where if someone did a deal, there's always the why behind it, right? God knows if that actually happened. I see. I don't do a whole lot of gaming deals, which is part of the issue. Is I don't see. There are a few really great attorneys that are in the gaming space and the esports space, and I have not yet been fully invited into that space. I think I've negotiated sort of esports team agreements, but I don't think I've ever done a specific deal. But
So, okay.
that one sounds interesting. The terms sound interesting because yeah, it's a long-term thing, and I would think that you would want to add some more value on the one side. And what are the real numbers there? Like, why is it that way? Definitely want to know why. And I do ask. That's an important point though. Like, I will go back to the business side and go, hey, this usage is a little long. Like, did you mean that? Or this fee, did I miss a comma or something? Like, what happened here? So it's always important to check in. And if I checked in, then good luck. I don't know what happened there.
So this one, let me make sure if I got this research right. My research says you had a morality clause triggered because a creator crowd surfed at a concert. Does that sound like something that you had happen?
That did happen. And I will say this. Morality clauses, people think it's always the big bad stuff. That someone comes out as, this tyrant, fascist, whatever, and they have all these horrible things that they say, and it's so clear cut and obvious. Yes, those things do happen. But what really, really makes my day long is when it's the little stuff that's on the cusp, that's on the edge, that the brand is trying to, be the moral police and just kind of push the envelope as to what's considered a violation of the morality clause. It's these little things. Oh, they refilled their soda too much at the store. Like silly things, right? Like it's when you get into that realm, that's really where the fights are. The big stuff, I go back to my client and I go, what were they thinking? Like of course that we're out of this. Of course we got hosed, so there's no way we can do anything about it. But it's that little stuff, the little inkling things. I mean, when you're at a concert and you're dancing and you're crowd surfing and you get on stage and you wave and you jump back in and stuff like that, like there are a lot of shows that are like that. So why wouldn't that be a problem? But if you're there for a brand, maybe they didn't want that. They'd said nothing of the sort. They assume that you're just going to go to a concert and have fun. So yeah.
So, what's the worst advice creators are getting from other creators on TikTok about contracts?
I don't think that they're getting really bad advice. I think that they're just getting limited advice. I think that there are some, people talk about perpetuity, they talk about that, you know, those kinds of things. And so I think that the general sort of zeitgeist is kicking in about what they should and shouldn't be looking out for. And there are, I have colleagues who get online all the time on TikTok and everything and will, give little nuggets of information and they have tracked throughout. I will go back to sort of the equity deals. I think if they're pushing equity and they're getting into that realm, I think that is a little dangerous and that they should be a little more conscientious about why they're doing it. Um, I think that there is a plot for it. I think there is a way for a creator to do really well in the equity play, but people should be watching out for why and how that works.
So we're running up to an hour. I still have more questions. I guess we're just going to have to put these off. I really enjoyed it. Maybe we'll have to do this again.
Sure,
It was a
sure.
great topic.
Yeah, and thanks for having me. I appreciate it. I could talk about this all day, and consequently, tonight I'm teaching a CLE on right publicity in the creator space, so I'm nice and warmed up. But Zane, it's been a pleasure, and definitely if people want to connect with me on LinkedIn and everything, I'm very loud there, and happy to grow my community there, and hear anybody's questions or anything. It'd be really fun.
So tell me about. I just have one other thing because you said you regularly post there. Tell me about some of the recent uh, posts that you made.
Sure.
Maybe talk about one that was more well received recently. I'm just curious as to what kind of content that works best.
So I certainly don't track. Again, I'm into the sort of the pull marketing, so I really don't track a lot of engagement. I don't usually get a lot of engagement. I kind of put it on there and let it like just simmer. But
Hmm.
really, the structure around it is every Sunday I post a Sunday Scaries, and they're numbered. And what's interesting about that, and the reason why I'll never stop, regardless of engagement, is because that number indicates the number of weeks that my law firm has been live and existing. I started week one and I haven't given up since. So if we're on week 125, whatever, that's how long Poe Law has been in existence. So it's sort of a counter. But what I usually post there is I will draw from the news, something about influencer marketing or social media, and I'll try to pull an article and I'll give my comment about it. Recently, I think the last one was about these beauty and dermatology brands targeting young creators, so
Hmm.
15, 16-year olds, and the questions surrounding the ethical questions surrounding, and the health questions. Are these, is it healthy for a young kid to be putting all this stuff on their skin? Or, what's going on with the payments and what's going on with the parents and their intervention? And is there enough regulation? Is there enough coming from the courts to say, listen, parents, I don't care if you're splitting the money with them or if you're stealing the money for, like, we have to start setting these kind of rules into place, and look out for their health and their well-being, because people are tempted, even parents are tempted to put their children in front of the ring light and say, hey, you're doing brand deals now because we can make good money off of this.
Yep. That's interesting. Well, thanks, Frank. I really appreciate